Members, we turn now to the Building Pools Amendment Bill. The question is that Part 1 stand part. Jacinda Ardern.
Oh, thank you, Mr. Chair. Mr. Chair, it seems timely that as we come to debate this bill, a flyer from KidSafe arrived in the mail, which a number of MPs may have received. And I just want to point out, because they've been massive advocates in this space and have repeatedly called on this Parliament to make sure that we do not lessen the current safety provisions that exist. And it has to be said that the Fencing of Swimming Pools Act, FOSPA, has been incredibly successful in reducing the number of drownings. So we've gone from 100 in the 10 years before the Fencing of Pools Act to 30 in the 10 years to 2012. So no doubt it has had an incredible impact. What we need to be debating here in this House today, well, the primary consideration for the Labour Party in the context for debating these parts for us has been what are we doing to further reduce down the number of both deaths and I want to add injuries, because that was a significant point made by submitters on this bill. So that's been our primary consideration, and it was from the point at the very beginning when Shane Jones, originally in government, began a consultation process on this act with the view, and I know this because I went back and read the beginning of the consultation document that Shane Jones put out as Minister, the primary goal of reducing drownings even further. And that is in direct comparison to the discussion document, because that process, for reasons I'm unsure, was dumped and restarted by the Honourable Nick Smith. And when I went and read the beginning of that document, drownings were mentioned, but so was a reduction in regulation and regulatory compliance. So there was a different focus. There was an additional focus added at that point. But for us, the primary goal has been quite singular. And from KidSafe perspective, look, they've put out this information on the number of injuries and deaths for children in New Zealand. Over 60% of all under 5 injuries happen in the home, and they do point to the number of drownings, 12%. They advise that you use gates and stairs at doorways for pool owners. Have a compliant fence. Now, their view of what a compliant fence needs to be and what this bill proposes is quite different, and I do want to talk about that a little bit, because the schedule of this bill does significantly change the way we define what is acceptable as an enclosure around a pool or immediate pool area. But, Mr. Chair, if I could just give a little bit of context at the beginning of this committee stage debate, that when we first started this debate, we entered in good faith and voted in favour because the Minister told this House that the regulatory impact statement told this House that this bill would save lives. And yet when we got to the Select Committee, the overwhelming evidence from submitters was that their view, and they were experts in the field, their view was the opposite, that in fact we were diluting, in their view, a number of the preventative factors that had been in place. Now, I will concede that there has been considerable change by Select Committee on this bill. Good change, and I thank officials and Select Committee members for that. And one of the most significant changes has been around compliance. And if I were to find where that was out, I believe that was in Clause 12 of the bill, Part 1, Clause 12. The compliance regime for pools obviously is managed by local councils. Originally, the first draft of the bill stipulated that we would have certainty around the inspection regime. At the moment, it was a bit ad hoc. There were some councils that inspected on a different cycle than others. By and large, though, many councils tended to inspect around the 3-yearly mark, and we know that from Auckland Council that was the case for them, because they came and told us that they inspected every three years, and that when they did that, I believe it was 3 years, and when they did that, they found that 65% of pools, when they did their inspections, were uncompliant within a 3-yearly time frame. The bill, however, I will grant you this, wanted to create uniformity because some councils were not inspecting that often. So they chose 5 years. And for some councils that would have been a lift, but not for everyone. So the select committee took the evidence base that said, look, if some councils are inspecting at 3 years and are finding a lack of compliance, and we know that all of the drownings that have occurred in New Zealand, or I believe at least the majority of them, there have been uncompliant fences. It wasn't that the law had allowed a loophole that allowed a drowning, it was that they were uncompliant fences. Then surely compliance would be the thing that would be most likely to prevent deaths in New Zealand, to prevent drownings, preventable drownings in pool areas. So, Mr. Chair.
Jacinda Ardern.
So, Mr. Chair, compliance needed to be absolutely at the top of our radar, absolutely. So it was put at Select Committee that perhaps, yes, having a uniform time inspection cycle was a good thing, but let's lift the bar. Let's not have it at such a large lead time that you could have disintegrated fencing or latches and so on. So I'm very pleased that that was changed at Select Committee to 3 years under, I believe, what would be clause, roughly around clause 12, I think, is where the inspection regime is. And we are absolutely supportive of that. Now, other gains that were made by the Select Committee included broadening the purpose beyond just drowning to injury. I still vividly remember I believe it was the paediatricians who came to the Select Committee and described some of the injuries, including significant brain injuries. So yes, we have fixated on death by drowning, but the ramifications of a child who is in a pool for just a few seconds without supervision is absolutely crushing. The acceptable solution under the Building Act is now the one specified in the schedule to the old Fencing of Swimming Pools Act, which is excellent. The discretion to vary from that solution to another or to exempt pools is the same, so it's no wider in breadth, and the test for its application is the same as what we had under FOSPA. And I have to say there was a really a lack of information out there for a lot of the groups who came to Select Committee. Their understanding of that transference, that message simply hadn't got through, and I can understand the alarm that they had, and it was rightfully placed. And it also, the bill now provided that information provided to councils for spas and other small pools would help them distinguish, because the rules now around a spa being allowed to have a lockable lid is a big change, and one where we are going into somewhat uncharted territory. So we have a number of areas where we've had concerns with this bill. But I have to say, there was one that really stuck for us, and it's set out in the schedule, part 2, and I want to bring that up in the bill. And that talks, it really defines the way that a pool area must be enclosed. And it says in the schedule, and there has been some changes here, but where a building forms all or part of an immediate pool area. So if you'll imagine that you perhaps have a house form one side of the barrier around a pool area. So you might have a fence, 3-sided, and then it's the maybe a ranch slide around into the pool forms all or part of an immediate pool area barrier. So it's not a 4-sided fence. It says doors between the building and the immediate pool area must not be able to be readily opened by a child, and must either emit an more audible warning when the door is open or close automatically after use. Now what that means is that you could have a ranch slider, for instance, that could be opened, but when it's opened an alarm might go off. But you are, for all intents and purposes, in the pool area at that point. There's an alarm ringing, but you're in. Now, our major concern was that this is not proven as a way to prevent drowning and harm, an audible alarm. It's not proven. And that we know a contributing factor to drownings in an area that a pool that might be compliant, fencing that might, is lack of supervision. And so we cannot allow any of our regulation in this area to be reliant on the most fallible thing of all, and that is the constant attention of an adult or of supervision. Because if we rely on that, we know we will fall down. And we are relying on an adult hearing that noise and responding to it. Now, what suggests to me that if a kid's able to pull open a door and get out that door, there's probably no one around in the vicinity. And if you're in a large house, who's to say they'll be able to hear that audible alarm? A. B. Who's to say if that alarm doesn't get triggered every so often and it doesn't drive everyone in the household crazy to the point that they disarm the alarm? Now, that is a reasonable assumption because we know that has happened before. There was, I think it was evidence from a study in London of smoke alarms installed for free in low socioeconomic neighbourhoods. And in small flats, the alarms went off regularly, so what was the response? They were taken out by the owners. They were just disabled because they drove people nuts. Now, I have the same concern about being reliant on these alarms. So we have an SOP which basically